Number 17, Sign-On Guyver versus Lydia Hubble.
Everybody involved in this matter, please come forward. All right, let me get you both to raise your right hand, face me. Raise your hand, please, ma'am. Each of you solemnly swear affirm testimony about to give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God. All right, I'll invite you all to have a seat. All right, counsel, it's your motion.
Yes, Your Honor. This is my motion to extend the order of protection. If Your Honor will remember, there was an order of protection entered in June of last year. The order actually covered my client as well as the party's child. Since that order was entered, there was a trial in juvenile court establishing a parenting plan that will go into place when the order of protection on the child is lifted. Ms. Hubble had come back at one point in time to try to modify the order of protection to lift it so that it did not cover the child, and Your Honor felt that it was not appropriate to do so at that time. The one-year mark has now passed. I believe it was June 15th that it passed. However, my client would like to extend the order of protection to cover himself. Ms. Hubble, throughout this 2-year process, we started in 2014 with all of this, has continued to escalate in her actions against him. She has violated...
Are you saying she's violated the order of protection?
She has. She has harassed him against the order of protection by constantly posting things on Facebook about him, claiming that he's a terrorist, claiming he's a batterer. He has never touched her. There have been 2 orders in the juvenile court saying she's not to post anything on Facebook about him. Two orders from magistrates, 1 order from the juvenile court judge. She has continued to post over and over again. We had a contempt trial back in January where she was found guilty of 19 counts of contempt. There is a hearing on an order of protection.
Now, did they incarcerate her?
They did not. They reset it for hearing and told her if she removed all the posts that they would not incarcerate her. She removed all the posts before the hearing on the matter, and then she has now started posting again. So our next recourse would be to file another contempt petition in juvenile court. It's not seeming to do much, but my client is very concerned that if this is how she's treating the lower court's orders about just posting on Facebook, that as soon as this order of protection is lifted, she's going to start harassing him again, texting, calling, emailing like she had been before.
Well, help me with this. Is there any reason y'all haven't sworn out a criminal warrant against this woman?
There was a criminal trial on the events that prompted the initial order of protection. She was found guilty by a jury. She's currently on probation for 6 months.
All right, but listen to my question. If she's violating the order of protection and you swear a criminal warrant out on her and she's on probation, she'll go to jail. Is there any reason we haven't done that?
Well, the probation just began at the end or early June. The police were alerted about the order of protection violation. There is a trial set for that, or a status hearing set for that, July 18th on the order of protection violations. Now, that was done a while ago. Since then, she's done it over and over again.
So you have sworn out a violation warrant on her?
We have.
Okay.
Mm-hmm.
All right. Ms. Hubble, let me invite you to the podium, and let me hear what our circumstances are.
Well, first of all, Your Honor, this has been an abusive process from day one, from when it started in juvenile court. And when they first got this order of protection last year, they made a lot of false allegations. I wasn't really given a fair hearing that day because it was rushed, and so there's a courtroom full of people, and I've got ADD, and I wasn't really prepared. And
I will tell you, ma'am, I kind of remember this case.
You can't remember?
No, I can remember this
Okay,
case.
you probably remember parts of it, but you probably, when I've been here before, you've made comments which you didn't really have all the information. But what happened, it was, he and I were not married. We had a child out of wedlock. And when my daughter was old enough to go to school, we co-parented. We had an agreed order, which was almost 50-50 parenting. He was entitled up to 180 days of parenting time, and I had no less than 185. And I was my daughter's primary caregiver and her primary attachment figure her whole life. And I'm just giving you some background.
No, here's what you need to understand. This isn't a trial, this is a motion, and the scope of this hearing is very, very narrow.
Okay,
the question is there a basis to extend this order of protection? The court's already granted the order of protection. We're not going to retry anything that occurred in juvenile court.
Okay.
Now, since this order of protection was entered in this matter, when was the order of protection entered? Let's see.
June 15th.
June 15th of last year. Have you posted derogatory statements about this man on your Facebook page?
I have not done one single thing at any time in this past year to violate the order of protection as you wrote it.
So I understand your choice of words. You're not harassing him.
I am absolutely not harassing him. He has to go out of his way.
Excuse me. We both can't talk at the same time. You haven't posted derogatory comments to the public about him?
That was not in your order of protection, Your Honor.
The word harassment was in my order of protection, and this court would consider that harassment. Were you found guilty of criminal contempt down in juvenile court?
No.
Remember, you're under oath here. Perjury
I know I'm under oath. It was, she did not ask for...
Excuse me. Perjury carries 2 to 10 years in the penitentiary. So I'm going to ask you again, were you charged, so we're going to take it step at a time, were you charged with criminal contempt in juvenile court?
It was civil contempt.
Civil contempt?
Yes.
And did the court order you to remove Facebook postings or you would go to jail?
I removed the
post.
post.
To my question.
I don't recall.
You don't
recall? I remember in her order she said she didn't feel like going to jail would do any good because she knew I was willing to go to jail, standing up for my rights that he's been trying to deprive me of.
Let me say, I don't feel the same way about that. My position is people violate my order, and I have anything to say about it. They generally don't go to jail. But let me suggest to you, ma'am, based on what I've heard so far, it appears to me that you have been posting harassing statements on the Internet, and that's your doing. Nobody makes you put these things on the Internet. You put them on the Internet. Is that right?
Your Honor, this is for appeal. For the purpose of appeal, I want to make it clear that I'm asserting my constitutionally protected rights to speak out against the abuse. He has to go out of his way. He says he wants no contact with me. He has to go out of his way. I'm not posting on his Facebook page. He has to go out of his way to come to my Facebook page. He's stalking me on Facebook. And then he's complaining about it.
Wait a minute. You're putting these things out there for the world to see, and when he looks at them, you're claiming he's stalking you?
If he doesn't want contact with me, and when I send him...
Let me ask you to wait just a minute. Do you have any copies of these, Ms. Rice?
I do, Your Honor. I submitted an attached to the motion. The order that was attached to the motion from the contempt trial has a good sample of what the judge found. So the couple admitted to in court to posting all of these posts and Dr. Smith sent them, where she said, it's outrageous that a Turkish man can come here and terrorize my family like this. She posted...
All right, hold on a second. Let me ask you to step around, ma'am, and have a seat over here. I'm going to give you a chance to come back and address the court. Come to the podium, counsel.
Your Honor, I brought copies of the order from the contempt trial. I've already submitted a copy with the motion, but I do have another copy for the court.
Well, I'm sure it's attached to this, but there's so much attached to it that I can't find it.
And I have a copy from Ms. Hubble as well. Your Honor will see in the order itself the court findings that she admitted throughout testimony. She was the author of the Facebook post on number 9 of page 5 of the court order. Some of the posts that she had posted, let's see a good example. Count 10, my daughter's dad is totally focused on his own needs. What kind of considerate father would lie and cheat to abruptly cut a 6-and-a-half-year-old girl off from her mother? Count 16, it's outrageous that it's so easy for a Turkish man to come here and terrorize my family like this. Count 17, she posted an article titled Rapist Dad with a picture under it saying, the judge took my daughter from me and gave her to the man who fathered her by raping me. Now a rapist has full custody of my daughter. At no point in that post did she clarify that was not about Mr. Gader. Count 20, Delara's father is a batterer. How can anyone pretend that he isn't? Again, he has never touched her. There's never been any testimony that he has touched her, Your Honor. Count 21, I'm still hoping Delara's dad will get ordered to go through a batterer's intervention program. Count 22, I would hate for my daughter to die of a heroin overdose as a teenager because her father is a selfish pig.
All right, thank you, counsel. Ma'am, step back around to the podium, if you will. Now, juvenile court has already found that you did those things.
Yes, and I absolutely did it. I did do those things, and I did them in protest, and the judge understands that, and she reflects that in her order. This is a civil right. The whole case in juvenile is a civil rights case. This man believes he has a constitutionally protected right to keep me from having a relationship with my daughter, and from speaking out against it.
Excuse me, ma'am. Please don't interrupt me again. Let me explain something to you. This court is the one that cut you off from your daughter as a result of your outrageous behavior. So you're the master of your own destruction here. The court is going to extend this order of protection.
I didn't finish. I didn't give you the statutory grounds for why you should not.
Then you give them to me real quickly.
Okay.
Before I rule in this.
Statute 36, Section 363608, that which she referred to in her motion, says that if there has to be a change of circumstances sufficient to warrant the modification. There has not been a change in circumstances. As I said...
I'm sorry, I'm not sure what you're talking about.
Okay, well...
There doesn't have to be a change in circumstance for this court to extend an order of protection.
That's what the statute says. Do you want to go hand this to him?
It's not necessary. The court's going to extend this order of protection for another year. And counsel, in your order, put in it that this court considers the posting of derogatory statements against the petitioner on social media to be harassment. So I'm trying to help clarify that for you so that you will understand that if you post things on social media against this gentleman when the order of protection is in place, you'll be violating the order of protection.
Well, and I do want you to understand, too, that the Supreme Court's found that Facebook postings are constitutionally protected speech.
That's fine. You take it to the Supreme Court. If they overturn me, I'll grin and say, yes, sir. Okay?
And, Your Honor, I would ask that in the order be clarified that not just when she specifically references his name, her new thing is just to call him Delara's dad or my abuser or my stalker. So I would just ask that in the order it clarify that anything that a reasonable person would understand is about him.
Well, let me say, counsel, I do think, in fairness, it would have to be derogatory comments about the father of her child or directed against him. Now, if she talks about a stalker, well, that could be lots of people. So, but the court's position is if she identifies this gentleman, uses words that identify this gentleman, then the court will consider that a violation.
And, Your Honor, I would also ask, in the extension of the order of protection, if it's possible to have limited contact through the juvenile court order. What we're going to try to do is use the My Family Wizard app for any kind of communication. Now that the order of protection is lifted from the child, if Your Honor is lifting it from the child, the parties mother can start supervised therapeutic visitation. So in order to coordinate that, if they use the My Family Wizard app, limited only to purely discussing the child and exchanges with the child and not harassing messages.
Well, let me suggest to you, counsel, any communication between these two, it appears to me to be problematic. I'm not familiar with the app you're talking about. If you're comfortable with it, then I'll live with it, but it really sounds to me like that's something under the purview of juvenile court. I mean, aren't they the ones that are dealing with the issue of parenting time?
Yes, Your Honor. If the order of protection is in place, then any communication under that app would be a violation of it. So I just ask that in the order of protection extension order, it clarifies.
Well, what I'm saying is, if you and your client are comfortable with that, then you put that language in there. The only reason these two should have any communication, as far as I'm concerned, would be medical emergencies involving the child, or parenting time emergencies. If juvenile court is setting parenting time for this lady, then the reason would be if the car's broken down, stuck in traffic, broken my leg, and I can't exercise parenting time. So, and I will lift it in regards to the child, because I haven't heard any statements that would indicate that she has put the child in danger, although I do want you to understand, ma'am, apparently the custody issue in this case is going to be under the control of juvenile court. But one of the considerations in regards to parenting time in custody is the willingness of the parties to promote a good relationship with the other parent. And posting derogatory comments about the other parent is something that could end up resulting in the juvenile court saying you're not entitled to any future parenting time with the child. So you try to use good judgment about this. Understand you're upset, but you really need to try to put your child first here if you want to play a role in its life. Anything further, counsel?
No, Your Honor.
Judgment of the court. Well, it would have been nice to do it if we intended to do it. Counsel, we've heard back from Mr. Perez.